All rise. The Court of Appeals Division 1 is now in session.
Please be seated. We're here today in our case 1CA CV160703, BURKE versus Bank of America. Each side will have 20 minutes to do their argument. Appellant, if you want to have time for rebuttal, you're certainly entitled to do so, but you'll have to keep track of your own time. We are recording this argument, and in a few days you can see yourselves on YouTube. Because we're recording it, please identify your client and yourself when you begin so we can keep everybody straight. We've read the briefs, we've read the record, we've conferenced the case, so we're familiar with the facts and the law. So when you come up to argue, launch right into what you would like for us to consider. Counsel, you may begin.
Good morning, Your Honors. My name is Amy Sells. I'm with the law firm Tiffany & Bosco. I am here on behalf of Appellant, Bank of America. I intend to preserve 5 minutes of time for rebuttal, but we'll see how things pan out. Your Honors, this case is something like a peanut butter and jelly hamburger, which, by the way, are surprisingly good. But you look at it and you think to yourself, gut check reaction, this might not work. But when you give it a chance, you'll see that it does. Leases such as the sublease at issue here, they're rare. But when you do come across them, you find that they share certain commonalities. Among those commonalities is a broad array of rights that are provided to the leasehold mortgagee. And there's a reason for this. It's because the parties to this transaction understand the importance of the role of the leasehold mortgagee, and there is an understanding that we want to give this leasehold mortgagee substantial rights because it is assuming substantial risks in this sort of a transaction.
But we do define the rights of that mortgagee by the terms of the agreement that the parties into, correct?
That is correct.
And there's nothing that says we infer anything but the specific. We never infer intent. We don't go beyond the specific provisions of the agreement when we're interpreting it.
Yes, that's correct.
Okay.
And among the risks that we consider that the leasehold mortgagee is taking, first of all, their interest is not in the fee estate, of course, it's in the leasehold estate. Also, typically, these sorts of subleases.
You don't dispute the general rule that when the leasehold estate terminates, the mortgagee's interest then also terminates.
I don't dispute that general rule. However, I do think that the facts of this case are consistent with that general rule. However, they are more of an expansion or a modification of that general rule. That general rule, and
to avoid the general rule, you'd have to rely on specific contractual provisions that defeat it.
That is exactly right, Your Honor.
Where are those contractual provisions?
Those contractual provisions are, let's see here, there are several. The only time, when you look at the lease, the only time that you see that the lease is talking about the leasehold mortgagee losing any of its rights, either under the sublease or with respect to the leasehold estate, is when it is getting paid in full. And so those provisions are 12.1H, 12.2, 12.4, 12.8.
So you're arguing that the termination of the sublease does not terminate any debts that have been incurred against that property during the period of the sublease.
That is correct. Well, maybe we should back up. I think that there are concepts that are discussed in the briefing that are vulnerable to being conflated that we should flesh out, because when they are conflated and used interchangeably, it can muddy the analysis. There's a difference between termination of the sublease as a whole and then termination of Ms. Robertson's rights under that sublease. What we're talking about and focusing on in the briefing, and I'll talk about the consequences of both of those concepts, but what we're focusing on the briefing is Ms. Robertson's termination of her interest under the sublease. And what Mr. Burke is arguing is when she no longer had an interest in the property, then Bank of America's deed of trust automatically extinguished. Now,
That kind of sounds right.
it kind of does, but let's talk about the arguments within the arguments. One of the arguments might be...
Well, I guess before you do that, Louis, tell me why that's not right.
That is not right, because what that is essentially saying is once a trustor, well, it's saying two things. It's saying, number one, once a trustor no longer has an interest in the property, then that deed of trust no longer can exist against the property. We know that that's not necessarily always the case. For example, if I am a first position lender and I have a first position deed of trust and an HOA comes in behind me with their assessment lien and they foreclose against that assessment lien, then the purchaser at that foreclosure takes title subject to my first position deed of trust. Notwithstanding that my trustor no longer has an interest in the property, my deed of trust still continues to encumber.
Why would you have 12.1F then in your agreement? So your position be our thing stays against any subsequent sublessee, right? Our encumbrance stays against the subsequent sublessee.
Yes.
Why would you have 12.1F then?
Well, 12.1F, okay, 12.1F is the one that says that if the leasehold mortgagee doesn't timely enter into a renewal lease with the sublessor, then we are abandoning and waiving our claims against the sublessor. A couple points on that. First, we read that as we are abandoning and waiving our claims against the sublessor relating to his obligation to enter into new leases with us.
So you want us to add provisions of the contract that aren't in it?
Nope, not at all.
You said we read that as adding an additional subset to the language.
Well, we can put that aside and focus truly on the language here. And it says that we're waiving and abandoning all rights against the sublessor. That is not waiving and abandoning rights with respect to the sublease. That's not waiving and abandoning rights.
What other mechanism is there to proceed as the sub-mortgagee if the claim isn't against the sublessee?
The claim isn't against the sublessee. It is not against the sublessor.
It's confusing,
It is
isn't it?
against the property. It is against the leasehold estate, which continues to encumber.
If that's the case and the sublease is terminated, then you're saying you've got a claim against the fee estate, right?
No, not at all.
What estate is there if the sublease is terminated? What is there but the fee estate?
The sublease isn't terminated. The fee estate continues. I think what you're talking about is if there is a absolute termination of the sublease as a whole. And the sublessor here did not have the right to terminate the sublease as a whole. If you look at the remedies provisions, and that's at Section 16, the remedies that are given to the sublessor upon an event of default by Darlene Robertson, you will see that the sublessor never had the right to terminate the sublease as a whole. What he had was the right to terminate Ms. Robertson's interest under the sublease.
And that's 12.1F then allows you guys to step into that and say, all right, we'll assume the sublease. Otherwise, you'd be saying that they can never dispose of this fee simple property because there would always be the sublease that attached onto it until you guys are paid off.
That's correct. That's correct.
But your contract doesn't say that. It says instead, you guys can step into it when it's been terminated under 12.1F.
Right.
And that was my point earlier. Why would you have that provision if your guy's right is going to run against the property forever until the sublease terminates under its own natural 20-year term?
Well, that brings me back to the original point that I was making in the presentation, is that the leasehold mortgagee is assuming extraordinary risks here. And I think that this is a situation where it was hey, look, no matter how things might pan out in terms of the sublessee's performance under this sublease, we are making an assurance to you, leasehold mortgagee, that your collateral interest in the leasehold estate is going to remain. We are ensuring that the leasehold estate continues to survive, notwithstanding a termination of the sublease, notwithstanding a termination of Ms. Robertson's interest under that sublease. The leasehold estate continues to survive so that the deed of trust can continue to encumber that leasehold estate.
And
so I think that it is.
Had it due because you got notice that they were terminating and you didn't act on it.
That's right, but I think that our remedies. I'm sorry.
Yeah, but and I mean that brings up a fundamental question I have about this case. Is you had remedies, so I don't know. It seems it would be a lot easier if you exercised the remedies that you had rather than spending the time and effort to persuade us to read the contract in such a way to get you the rights that you already had.
Yes, I understand that frustration. I do definitely see the fact that we had other remedies that were available to us, but the fact that we didn't exercise, unfortunately, those remedies does not take away the issue that is here before us today, which is there an additional remedy that is available to the leasehold mortgagee?
Excuse me, but it does take them away in the sense that if you don't exercise them, you lose your rights under the lease and they're gone.
Well, assuming that those are our only rights, assuming that those are our only remedies, what you might expect to see in a lease such as this is a provision that says, and in fact we do have a provision, duration of mortgagee's rights. You would expect it to see leasehold mortgagee's rights under this sublease will terminate upon such and such occurrences, right? Payment in full, consent to a release of the leasehold mortgagee's rights under this agreement, and if the lease renewal period lapses, then leasehold mortgagee's rights are no longer. What this contract says is that if the lease renewal, at best, it says, if the lease renewal period lapses, well, then you've waived your rights against the sublessee or a sublessor. You haven't waived your rights against the leasehold estate because it still exists, and we know that.
But the leasehold estate doesn't exist anymore.
The lease, under the general rule.
You have a right against the leasehold estate until the leasehold estate is exhausted. Now, you said earlier, well, they didn't properly terminate it, but that's not the issue that you raised in this appeal.
We had never conceded the fact that it was properly terminated. If you go through the briefing, we have never said that the sublease was terminated. We say throughout that Ms. Robertson's interest under the sublease is terminated, and we attempt to explain the difference between the two. And I think that under the general rule, when you're talking about this general rule that's adopted in other states but not specifically adopted here in Arizona, and the cases that Mr. Glenn cites to in his answering brief, all of those cases contemplated a straight up and down lease between sublessor and sublessee. And I do acknowledge the fact that if the lease is properly terminated, and either because it was terminated or it expired by its terms, then it is the lease that creates the leasehold. And if there is no leasehold, then the lender's deed of trust has nothing to attach to. I understand that. But that presupposes, number one, that there was a proper termination, which here there was not. And it also presupposes that there are no contractual provisions and safeguards written into the lease for the benefit of the leasehold mortgagee, because in none of those cases
there
did the
were
leasehold
contractual
mortgagee
provisions that you guys, to protect you guys, to
Yes.
recognize that competing balance, and
Yes.
you guys failed to avail yourselves of those protections.
Of some, but not all. And I would say, in my mind, I look at this remaining remedy or protection as more of a catch-all. You know, the idea that if all else fails and you do not cure during the notice and cure period, if you do not enter it for whatever reason, are not able to enter into a new lease with the sublessor, then there is one final catch-all provision, the safeguard that will prevent you from losing your deed of trust.
Since I've got two questions. The first question on the earlier comment is not failure to pay the payments on the lease as required by the lease. If you don't do that, isn't the lease properly terminated? You seem to say that only if it's satisfied or if there's some canceling of the lease, only then is it properly terminated. But I would think if I have a lease and I don't make my payments, the company can terminate properly terminate the lease because I didn't make my payments.
Well, in that particular type of a lease, you're talking about two parties to the contract. Here we have three parties, the leasehold mortgagee being a third-party beneficiary in that lease. And so, yes, when Darlene Robertson committed an event of default, there were only so many remedies that were available to the sublessor. None of those remedies was a termination of the entire sublease. It was just a termination of her interest under the sublease, such that you still have two parties to this contract remaining. The leasehold mortgagee's interests still need to be dealt with, and the fact that the leasehold mortgagee did not timely enter into a new sublease, it's unfortunate, but yet there are still additional remedies available.
Well, and my second question is if we interpret the contract as you suggest, and I think as you just explained, then if the remedies are provided in the contract or exercised, that's no big deal because we still have our rights, and that seems to read contract provisions as meaningless, or certainly at least without a time limit.
Well, I feel that it is actually quite meaningful. It's not a loosey-goosey sort of a thing. There are, as I read it, it makes it very clear that the only time under which a leasehold mortgagee could ever lose its rights under this sublease is if it's not paid. I could not find any other terms in the contract that talk about when a leasehold mortgagee loses its rights. And it time and time again says that the only condition under which the leasehold mortgagee no longer has a right in the leasehold estate or under the sublease is when it's been paid in full.
The leasehold mortgagee loses its rights if it doesn't get paid? Is that what you just said?
No, once it does get paid. If I said that, I apologize. Once I meant was it.
We may have gotten sideways, too. So your position is that Robertson leaving the arrangement that was initially struck, or being taken out of the arrangement, however you want to calculate it, or however you want to say it, you've got a relationship between the Phoenician Trust and Robertson, and it generates the sublease, right?
Correct.
Okay. And you take Robertson out of that equation, you take her out of that contract role, but the contract continues for the benefit of a third-party beneficiary.
Yes.
Is that what you're saying?
Yes. You know, one provision that sort of speaks to that is the non-merger provision. Now, your typical non-merger provision will say that if the fee interest acquires the leasehold interest or the leasehold interest acquires the fee interest, then neither of these estates are going to merge. This particular non-merger provision is beefed up. It provides additional rights to the leasehold mortgagee. And it says that if either of these two things happen, for so long as the leasehold mortgagee is not paid in full, these two estates are going to remain separate and distinct. So, for example, if the sublessor acquires the leasehold estate, meaning that Darlene Robertson is out of the picture, the leasehold estate continues on, the fee estate lives on, and so does the leasehold mortgagee's deed of trust, which attaches to the leasehold estate in the absence of Ms. Robertson.
So it lives on, as you say, to use your language, but there's no real party making the payments under the sublease because the bank isn't making them. They had that option, right? They could have stepped in and done that. They're not making them. The trust, the sublessor, isn't making them because they're the ones the money's owed to. There's no third party, and we're going to superimpose a new sublessor arrangement over the top of an existing sublessee arrangement. That's still not going to get money to the bank, right?
I'm not sure if I understand the superimposed
Can
portion.
you have a sublessee arrangement where the sublessee has bailed on it, but we're not going to close that because after all, the mortgagees owed money, right? You with me? Presume
Yes.
I'm talking about the bank.
Yes.
So the bank is still going to look to that sublease arrangement because it's still in place, you said, and their rights flow through the sublease arrangement from the Phoenician Trust, who is the sublessor, initial sublessor. So we've got a lease that still controls on that property, just no one is sitting in the seat of the payor under the lease to the Phoenician or satisfaction of the bank's debt. What are we doing? How does that work? If the lease remains in place, but you don't have anybody sitting in the seat of the person responsible for the obligations under the lease?
Well, I think that the sublessor certainly has the right to fill that seat, and I don't think that it is any sort of burden upon the bank to continue to encumber. So it would be the person coming in's responsibility to take on the debt of the bank. Yes, they would take subject to the bank's encumbrance.
But it would remain the Robertson lease.
Well, I think maybe it's a little bit easier to speak about what happens here.
That's what I'm asking.
We have Mr. Burke in the shoes of the, yes, Mr. Burke stands in the shoes of the sublessor.
But he doesn't, does he? Didn't he jump ahead of this sublease and buy in?
No, I would say that he steps into the shoes of the sublessor because it was improper. It was improper for the Phoenician Trust to sell to him this property under the representation that it was no longer encumbered by our deed of trust. And so long, and it is our argument that this sublease is still alive and in place. If it is, then we still have a fee interest, we have a leasehold estate interest, and the deed of trust encumbers that leasehold estate interest.
How long was the original lease?
Just short of 100 years, I believe. 2078 is the term. Entered into in 1982.
So if they just let the property sit fallow, you guys would have no remedy at all. Because once you didn't exercise your right to step in, you can't step in now. So that sublease would survive till it expired, and then that would be free and clear. The fee simple would be unencumbered at that point.
Well, are we talking about if our deed of trust is still there encumbering the leasehold estate?
Well, I mean, you're arguing it was improperly terminated, but by its terms, it terminates at some point, and you guys would have no right to do anything after you failed to exercise your rights to step in. So at that point, it just sits empty for the next 80 years? I totally apologize if I'm not understanding. The way I'm phrasing the question.
If our deed of trust continues to encumber this leasehold estate, then we would have, and you were to find that it does, then we would have the right then to foreclose on the leasehold estate. And I think that, practically speaking, that Mr. Burke would not be...
I'm saying, assuming they hadn't sold it to Mr. Burke, so
yes.
It's just, they've given you the notice,
yes.
You don't step in,
yes.
And now what?
We could have still foreclosed. We could have still foreclosed and then stepped into the shoes of, if we foreclosed and then the leasehold estate then reverted back to the bank, which practically speaking it probably would, the bank would then step into the shoes of the sublessee. Which may beget the question, why then did you not just enter into a new sublease? But this is not a situation where I think the word used by Mr. Glenn was that the bank rejected its collateral. We didn't reject it. At this particular time, there is a change in the servicers. Loans are not securitized and dealt with today like they were back in 1982 when these provisions were drafted. And despite the servicers' best efforts, and mind you, it was the servicer acting on behalf of the servicer, not with counsel, whereas the Phoenician Trust was acting through counsel. I mean, I think that it was just an unfortunate series of events where...
Thank you, Counselor. Your time is
I'm out.
up.
Okay, thank you.
Thank you very much.
Thank you, Your
That
Honors.
does happen too, by the way, Counsel, running out of time. It does happen. Thank you.
Thank you.
Counsel?
May it please the Court, I am Joseph Glenn, and I represent Jim Burke, and he is here with me today with his wife, Kimberly Burke. I think this all comes down to the fact that, well, let me start with termination. There's been discussion as to
Gonna
whether...
start at the conclusion? Is that what you're going to do?
Yes. There's been discussion about whether the sublease itself was terminated or whether some smaller subset of Ms. Robertson's interest was terminated. Pursuant to paragraph 12.1D and section 12.1F, it refers to the termination of this sublease. It does not refer to termination of less than that. So pursuant to the terms of the leasehold interest, the sublease in its entirety was terminated.
At what point? By virtue of?
By virtue of the failure to cure the defaults. So when the defaults weren't cured, it was terminated effective February 4th. After that, the sublease provided Bank of America with an opportunity to enter into a new sublease. And that's important because the prior sublease was terminated, and the lease contemplates that. So when there's...
And there are time limits on exercising those remedies, correct?
Yeah, they had the opportunity to exercise those remedies, and it was spelled out in detail in those letters that your interest as mortgagee will be terminated if you do not enter into a sublease. That is what the
Within a
sublease
period,
says.
within a fixed period.
Within a fixed period. They gave 30 days.
30 days.
30 days after it's terminated.
So they were given notice. There was no surprise. I have one more question I wanted to ask your opposing counsel. All three parties were included in the negotiations of this agreement?
No. What happens here is when you have a long-term lease like this, and in a situation here where you've got multiple properties within the Phoenician Trust, they know that for people to purchase this kind of a property, purchase a long-term leasehold interest in the property, a lot of people are going to require loans. In order to do that, they put provisions into the sublease that would satisfy most lenders to say, okay, we can step in and take over the sublease if there's a default. We can cure it, and we can enter into a new sublease.
So was the bank a party to the draft of the sublease?
No, they were not.
Second question, did they buy with knowledge of the existence of the sublease and its provisions?
Did who buy?
They weren't there when it was written. Did I say apply? I'm sorry if I did. Did they loan? Did they provide the funding to Ms. Robertson with knowledge of the existence and language of the underlying sublease?
There's a factual dispute below. There was a dispute as to whether that was the case or not, but by law, there was a recorded memorandum of lease. They were on notice of that when they loaned the money on that, and it's so that issue, and that's not an issue that they raised on appeal or addressed on appeal.
My point is they were
Sure.
not a party to it, so they weren't allowed to make a contribution in regard to the specific language of the provisions, but they certainly had notice it existed and didn't have to loan until they found out what the provisions of the sublease were.
That's correct. It was a take it or leave it. They could have loaned on the property, or they could have said, no, we don't like the terms of the sublease, we're not going to loan on this property.
Or we haven't seen the paper.
What?
Or we haven't seen the paper. We haven't seen the lease. We have no knowledge what the contents of the lease are.
Sure. And they took that risk when they made the loan. I will point out that this new argument that somehow there was a leasehold interest that wasn't terminated that they can still foreclose on is something that is inconsistent with what has been pled in this matter. The opening brief on page 18 says that the bank assumes for the sake of this appeal that the sublease was terminated. On page 9 of the bank's reply brief, the bank says this: the bank is not claiming that Ms. Robertson has a remaining interest in the leasehold upon which the bank is entitled to foreclose. That's just absolutely clear, and that's from the bank. And then you look at the case law in Arizona, the Moore versus City of Tempe case, which is consistent with law all across the country, that says a mortgage gives the mortgagee no greater interest than the mortgagor possesses.
Counsel, it has felt to me for some time since I've been reviewing this that the bank's position almost is, and I don't mean this in a pejorative fashion, that they have a right to claim against fee title. In other words, it's the title that survives above and beyond the sublease. Can you address that for me? Tell me I'm wrong.
No, I think originally, if you read the briefing from the bank, I think originally that's their claim. And then I think at some point they realized that that was untenable because law in Arizona and across the country says you can't have, as a mortgagee, you can't have a greater interest than the mortgagor. What they can only give you what they have. And Ms. Robertson, it's undisputed, and they acknowledge in this case, that she did not have fee simple title. She had a leasehold interest. So all that the bank could get was a deed of trust on that leasehold interest. And once that leasehold interest was terminated, there is nothing upon which the Bank of America can foreclose. They just have no option, which is why the Section 12.1F is so key and why it shows that there's nothing ambiguous about this lease. It says that if they fail to enter into, after it's terminated, after the sublease entirely is terminated, according to the terms of the sublease, it says this sublease is terminated, not some smaller interest. It says that if the mortgagee does not enter into a new sublease, it is conclusively deemed an abandonment and waiver on the part of such leasehold mortgagee of all rights to obtain such new sublease. Why new? Because the prior one was terminated entirely. So they would have to enter into an entirely new one on the same terms and conditions as the prior one. And they're also a waiver of all abandonment and waiver of all rights against the sublessor. So the bank was focusing only on the second half, but the first half is probably even more important, the fact that they're waiving any rights to obtain a new sublease. And so the bank is coming to you today saying, hey, wait a minute, we know and we acknowledge in page 9 of the reply brief that Ms. Robertson has no interest, her sublease was terminated, but we want the court to give us a new sublease upon which we can foreclose. And paragraph 12, section 12.1F says no. It's directly on point. And these provisions were not drafted in a vacuum. If you go back and look at some of the case law that's cited, go back to 1883, the Abrahams case in Maryland, we have a similar situation where where a leasehold interest, long-term leasehold interest, was passed on from party to party to party to party. The improvements kind of went into disarray. There was a default. The leasehold interest was terminated. The property owner, Miss Abrahams, comes in, builds 2 beautiful new homes on the property 6 months after she terminates the lease, and then a prior lender comes in and says, well, wait a minute. We've got 2 new homes now. We want to foreclose on this property. And the court says, no, your interest was terminated 6 months ago when the leasehold interest was terminated. That's 1883. And the similar cases throughout history. And I would point out that there's a couple of cases, the Glendale Federal Bank case in California and the Davenport case in Nebraska, both recent cases, spell out exactly what kind of remedies you would anticipate or a lender would want in a case like this. They say the lender has the option to get provisions that would allow them to cure the default. The lender has the option to ask for provisions that would allow them to get notice of default so they can cure it, and that they have an option to enter into a new sublease after it's terminated. The exact provisions we have in this case are mentioned in Davenport and Glendale Fed Bank. And the court in both circumstances said you don't have the right to do anything if you didn't follow the terms of the lease. And your rights are determined by that. And once the leasehold interest is terminated, there is no longer an interest upon which you can foreclose. And if there's no interest that Ms. Robertson has, there's no sublease because it's been terminated, they're barred from entering into a new sublease because they refuse to do so, there's nothing upon which they can foreclose. They have no interest. It's terminated. Case law all across the country is in accord with that. And the specific provisions of the sublease govern this matter.
I know your position that the bank has waived or not raised argument of the properness or correctness of the termination. Sure. Channeling your counsel, I would assume that what she would say is that no, when we made those concessions, we were saying we don't object to the fact that they terminated the original sublessor's interest in the lease, but that they didn't actually terminate the sublease itself. What What is your response to that argument?
Well, my response to that is that's a new argument that I've heard for the first time today. And the second is, if you look in the lease, if you look at 12.1D and 12.1F, it says explicitly termination of this sublease, not some limited interest of of Ms. Robertson. And in this case, without Ms. Robertson's interest, there is no leasehold interest. I mean, it's a theoretical impossibility to have a sublease.
Well, she could have transferred it to someone else. The sublease exists independent of Ms. Robertson, but at some point it can be terminated pursuant to the terms of the
Yes, and it was terminated in this case, and the provisions of the sublease itself speak to termination of the sublease itself, not some lesser interest that would allow an interest to survive.
And counsel, following on something I said, it is possible to terminate the interests of the sublessee, excuse me, but it's by terminating the sublease.
Yes.
You don't get to terminate the rights of the party contracting, but keep the contract in place.
That's correct.
There may be penalties under the contract, but that's different than saying, well, there's still a thing you can have an interest in. It's just not you that can have it, even though you're the signatory to the agreement. Fair?
Sure, and that's exactly why 12.1F says what it says. If you don't enter into a new sublease, you're barred from getting a new sublease. It uses the term new because the prior one was terminated. It doesn't exist anymore. So you have to, if you want to continue your rights, you get a new sublease. The last thing that I want to address is there was discussion about the merger provision that says that if there's merger, that doesn't extinguish the mortgagee's interest. Well, in this case, that scenario actually played out and had the opportunity to be of effect. In this case, the Phoenician Land Trust a few years ago offered all of these long-term leasehold interest holders to purchase out the fee simple interest. All of them had the opportunity. They had to pay X amount of dollars to do that. Ms. Robertson refused. She did not do that. Had she done that, by law, normally she would have the sublease, she would have an interest in the sublease and fee title, and normally that would affect a merger and would extinguish that sublease, which would extinguish the mortgage interest. But in this case, there's a provision that says if that happens, there's still a mortgage that Ms. Robertson still has to pay, and it's still on the property, even if she acquires that interest. But that didn't happen in this case. There was no merger.
And in default, the bank could have foreclosed at that point then.
Yes.
But that's not what happened.
That isn't what happened, and what also didn't happen was nobody acquired Ms. Robertson's interest. The Phoenician Land Trust didn't purchase Ms. Robertson's interest or take it back. They terminated it.
Did Mr. Burke purchase Ms. Robertson's interest?
No. Mr. Burke purchased fee simple title from the Phoenician Land Trust.
That was the reference I made a few minutes ago, or maybe it was the opposing counsel, but that he purchased something above the sublessor.
That's correct.
And what I meant was fee title.
Yes. And at the time he purchased, it was, he purchased in, I think, December of 2013. It was almost a year after the leasehold interest was terminated. And Bank of America had failed and refused to enter into a new sublease or cure the default. So unless the court has any further questions, we would ask that the ruling of the Superior Court be affirmed because the sublease was terminated and there's nothing upon which Bank of America can foreclose.
Thank you, counsel.
Thank
We
you.
appreciate your arguments today, and we'll consider them and issue a decision in due course. We're going to stand in recess and remain on the bench while the next case comes up. Thank you very much.